A very good evening to Dr. Rizal and everyone who's watching this video. My name is Tamara, metric number A155797, and today I'll be presenting on the topic of revision, and my case would be Nicholas Hui Chung Wang and PP 2020 1 LNS 229. Okay, so first we would go to the brief facts of the case. This was actually an application for a revision to remove a bail order that was given by the learned magistrate on 9th of March 2020. The applicant was actually a Singaporean national, and what happened was that he was charged under Section 15(1) of the Dangerous Drugs Act 1952. The respondent, who's the public prosecutor, did not offer bail to the accused. However, an oral application was made by the pupil in chambers who was representing the applicant, and he appeared on behalf of him. The magistrate, after hearing the submission, allowed the bail on 3 conditions. First, that he must pay the amount of 7,000 ringgit, with 2 sureties being both Malaysian nationals. And secondly, the applicant was to surrender his passport until the disposal of the case. And thirdly, the applicant is to report to the nearest police station twice a week. The applicant has now applied to this court, which is the High Court Johor Bahru, to use its revisionary powers to remove the conditions of the bail imposed by the learned magistrate. Okay, so the grounds of appeal in this case was that the learned magistrate has erred in law when imposing conditions of bail, because Section 15(1) is actually a bailable offence. So the counsel, she referred to the case of Muhammad Jalil bin Abdullah and another against public prosecutor, a 1996 case, where the High Court held the term shall be released on bail in Section 3871 of the CPC is actually mandatory. By virtue of this provision, a person accused of bailable offence is entitled to bail as a right. There is no question of any discretion in granting bail, and the court is bound to comply with the provisions of the law. Let's see what Section 3871 of the Criminal Procedure Code discusses. Section 3871 actually provides that when any other person other than a person accused of non-bailable offence is arrested or detained without a warrant by a police officer, he is supposed at any time while in custody or any stage of the proceedings before the court to give bail, the person shall actually be released by bail by any police officer in charge of a police station or by any police officer not under the rank of corporal by that court. Okay, so let's look at the decision of the case. The decision of this case is that the court is actually in the view that the learned magistrate had erred when imposing the conditions for a bailable offence. But what the High Court judge actually did was that she retained the 2 conditions, which was firstly for him to pay 7,000 ringgit and have 2 Malaysian sureties to bail him, and also he to submit his passport. Other than that, the reporting to the police station twice a week was removed, but the first 2 conditions were still applicable. Okay, so it's a simple case, and that's all. Thank you so much. Missing you, Dr. Rizal.